Okay, welcome everybody to the Stranahan event today. We are so very honored to have Justices Melody Stewart and Patrick DeWine here today to engage in a conversation. It's really an honor here. I'm Rebecca Zitlow. I'm the Dean at the College of Law, and my role today is just to welcome you and also to introduce Professor Lee Strang, who is the advisor to the Federalist Association and to the Stranahan Lecture Series. Professor Strang joined the faculty in 2008, was granted tenure in 2010, and was named John W. Stepler Professor of Law and Values in 2015. He was appointed the director of the Institute of American Constitutional Thought and Leadership, which is co-sponsor of this event today, in 2023. Prior to teaching, Professor Strang served as a judicial clerk for Judge Alice M. Batchelder on the Sixth Circuit. He was also an associate for Jenner and Block, LLP in Chicago, where he practiced in general and appellate litigation. Professor Strang has been a visiting scholar at Georgetown and Princeton universities and has garnered numerous awards for his scholarship. A prolific scholar, Professor Strang has published dozens of articles in the field of constitutional law and interpretation, property law, and religion, and the First Amendment. His most recent book, Originalism's Promise, A Natural Law Account of the American Constitution, was published by Cambridge University Press in 2019 and is the first book-length natural law justification for originalism. Thank you, Professor Strang, and welcome.
Thank you so much, Dean Zitlow. Today's Stranahan Forum, like the Stranahan series more generally, provides critical contributions, valuable viewpoints to our university's debate and discussion on important issues of law and policy. It's therefore my pleasure to introduce today's Stranahan lecturers, Justices Patrick DeWine and Melody Stewart. Both justices have extraordinary professional careers, so I'll just get a chance to note the highlights. It was wonderful actually learning about all the different things the justices had done. Justice Stewart was elected to the Ohio Supreme Court in 2018. Prior to joining the court, Justice Stewart served on multiple terms on the 8th District Court of Appeals. Justice Stewart has served more than 30 years of combined administrative, legal, and academic experience. In fact, for a while, she was a visiting professor here at the law school back a while ago, we'll just put it that way. Justice Stewart was an administrator for a healthcare management company, a music teacher, a civil defense litigator, a law school administrator, and professor before being elected to the Court of Appeals. Justice Stewart earned a Bachelor of Music degree from the College Conservatory of Music at the University of Cincinnati, and her law degree from Cleveland State University, and her PhD from Case Western University. Justice DeWine is serving his second term on the Supreme Court of Ohio. Justice DeWine has served at all levels of the Ohio judiciary. Prior to his election to the Supreme Court, Justice DeWine served on the 1st District Court of Appeals, and prior to that, the Hamilton County Court of Common Pleas. Justice DeWine graduated from the University of Michigan Law School and received his undergraduate education from Miami University. After law school, he clerked on the Sixth Circuit, practiced for nearly 15 years, served as the Hamilton County Commissioner, and was a member of the Cincinnati City Council. It's actually, in reviewing the biographies, it's heartening to see our leading jurists have such well-rounded and expansive backgrounds that they bring to their offices and their duties. In their conversation today, the justices will describe their views about the Ohio Constitution, the roles of the judiciary and other branches interpreting it, and what the Constitution should mean to us, Ohioans. Our conversation will last for approximately 35 minutes, leaving about 15 minutes for your questions and comments. So to get the conversation kicked off, justices, would you mind please sharing how you came to be a justice on the Ohio Supreme Court? Justice Stewart, maybe you want to go first?
Justice DeWine is senior to me, so he can go first.
The short answer is I was fortunate enough to be elected to the court 7 years ago. We're elected in Ohio, obviously. But for me, it really started, I went to law school, and I really wasn't sure what I wanted to do after law school. And there was a professor one day who held a forum that talked about judicial clerkships, and I said, that sounds kind of interesting. So I applied and was fortunate enough to be able to clerk on the Sixth Circuit. And that, to me, that was really kind of a formative experience. I wouldn't say I walked out of that there knowing I wanted to be a judge, but it was certainly something that was in my mind from that point on. I really enjoyed the chance to clerk for the judge I clerked for. I thought he was a phenomenal judge. I was just really impressed with the seriousness with which he took a job, the questions that he wrestled with, and how he did it. And so I always had that in my mind, and I ended up practicing law for a while, getting involved in local politics, running for city council, county commission, but still practicing law. And then I think one day I figured out that I like the politics, or at least I like the government part of it, but I like the law a lot better. And I had an opportunity to run for Common Pleas Court judge, so I did that, was able to serve there for 4 years, which to me was just really fun. I mean, I love what I do now, and I certainly wouldn't trade it for anything, but getting to be in the courtroom every day and seeing the crazy, unpredictable things that happen in a trial court was just a tremendous experience. From there I ran for the Court of Appeals and ultimately was fortunate enough to get elected to the Ohio Supreme Court. So that's kind of how I got here.
Thank you, Justice. Justice Stewart?
Like maybe many of you in the room, particularly students, I never, ever, repeat ever, thought about being a judge until I did. I, like most students who graduate from law school, think about getting a job, paying loans, learning as much as you can, and maybe being a litigator, although I know some students don't want to go into the courtroom. And so that's what I did. I started off doing civil defense litigations for 2 municipalities in northern Ohio, and I got into legal education when my legal writing instructor that I had in law school asked me to be an adjunct in the Department of Legal Research, Writing, and Advocacy at Cleveland State. And so I loved doing that. I loved legal education. I liked the scholarly aspect of legal education. And so an assistant dean position open, I did that, faculty position open. I loved teaching, I loved research and writing. At one point I even loved grading, not so much toward the end. That gets to you after a while. And then someone said to me one day, "You ever think about being a judge?" And I said, "No." And never, just not even in the realm of possibility. It just wasn't on the radar. And then when the person said this to me, and it was a person who was not a lawyer, I assumed that that person meant trial court. And I thought, no, I could never do that. I wouldn't want to see the man in Humanity Against Man that trial court judges see on a regular basis. I would be disappointed of lawyers who were not prepared, and I would want to call a party over and say, hey, you might want to get another lawyer, and that would be wrong. So I just thought, no, I could never do that. A trial court is just, whatever. And he said, no, appellate court. Being a law professor in the appellate court is more kind of aligned, as scholarly as academic. And I thought, wow, okay. And I looked into that, and make a long story short, I'm totally politically unconnected. And so because we have to run for our positions, that's not a good thing. And so I tried 3 times. I ran twice unsuccessfully. And I'm a person who doesn't believe in running against another judge or justice because I'm a different political party. I mean, these seats are open to anybody who's qualified. Let me say that. They have a right to run. But I was not going to run against someone because he or she was the opposite political party. I just never did that. So I always waited for seats to be open, either through retirement or some faction. So 3 times, third time was a charm. I got elected to the Court of Appeals in 2006, and in 2008 was being solicited to run for the Ohio Supreme Court. And I thought, wait, I've had this job 2 years. Can I learn it first? And so I did that, and I thought I had learned all there was to learn about being a good appellate court judge, and then 2 justices retiring in 2018. That was a good year for me. I just won re-election in 2016 so that I could run from cover. You all know what that means. That means you can run for a judicial position. And maybe you know or don't know, judges can't run for any elected office other than a judicial office and remain in his or her seat. We can run for, Justice DeWine and I can run for Muni Court or Common Pleas Court, whatever judicial seats, and keep our seats, but we can't run for city council or governor or commissioner. We'd have to resign. And so I could run from cover. If I didn't win Supreme Court, I kept my job on the Court of Appeals. And I was fortunate enough to win and be the first woman of color ever elected to our Ohio Supreme Court.
So, Justice, you both are at the Ohio Supreme Court now, and the Ohio Supreme Court, one of its primary functions is to interpret and apply the Ohio Constitution. Is there, and if so, what do you think is the right way to interpret the Ohio Constitution? Maybe Justice Stewart, if you want to go first this time.
I don't necessarily believe there is a right way to interpret the Constitution. For me, the Constitution, at least our Ohio Constitution, is a living document. It's a document that can be changed by the people of the state through proposing a constitutional amendment. It can be changed by the General Assembly, and it can be changed by Constitutional Convention, although I don't know if we've seen one of those in quite some time. And so it is a historical document that gives us fundamental rights and carves out who we are, but with an interpretation, in my mind, for modern times and an ever-changing populace in the state. So there are times when I think a textualism approach is the right approach, and there are some times when I think structuralism or a historical perspective. And so for me, it's a big depends, and I think having a combination of all of them is not necessarily a bad thing.
Justice DeWine?
Yeah. I think when you start thinking about how what methods judges use to interpret the Ohio Constitution, it's important to keep a couple things in mind. And they're a little different than constitutional interpretation when it comes to the federal Constitution. One is that every provision of the Ohio Constitution was approved by the voters. So the original 1851 Constitution was created through a constitutional convention, but then that Constitution was actually put on the ballot, and voters voted for that Constitution. Since then, the Constitution's been amended, I think, about 170 times. Each of those amendments was put to the voters, and the voters voted for that amendment. The other thing to keep in mind is that the Ohio Constitution, unlike the federal Constitution, is relatively easy to amend. It just takes petitions from 10% of the electorate to put something on the ballot, or a vote of majority of the General Assembly to put something on the ballot. And then once that happens, it just takes 50% plus one to amend the Constitution. So from those two things, I think a couple principles flow as far as interpretation. One is, one is that because the Constitution is easy to amend, judges shouldn't be doing that for the people. The argument for a living Constitution when it comes to the federal Constitution is, well, it's really hard to amend the federal Constitution, so judges have to take that into account. You can agree or disagree with that, but that's generally the logic that's been put forward for kind of living Constitution interpretation in the federal context. That doesn't apply in Ohio because the state Constitution is easy to amend. And second, because these things are directly voted by the people, it seems to me the proper mode of analysis is to say, how would the reasonable voter who voted for this amendment have understood that language? And our duty as judges is to reflect that meaning. If the reasonable voter who voted for a constitutional amendment in 2022 or 1912 or never would have understood language a certain way, then our job is to apply the original public meaning of that. And if people think the Constitution should be changed to adapt for the times, then that is certainly their right, and we have a process to do that. But I think generally, as judges, particularly when it comes to the Ohio Constitution, applying the original public meaning is the best methodology to use. And that's really, if you look at our case law, that's actually what the Supreme Court has said. First case where the Ohio Supreme Court found a law to be unconstitutional, a case Rutherford v. McFadden, which I think was 1806 or 1807. What the court did was, it was a question about what the jury trial right meant, and the court said, well, how was the jury trial right understood at the time the Constitution was enacted? And so we've always really applied that methodology, and I think that's the right way to look at it.
And if I can just quickly interject, and to some degree, I agree and disagree with my colleague, because one of the problems with the vote on the Constitution early on, 1851, that more than 50% of the people in this room wouldn't have been able to vote on it, because females weren't eligible to vote, people of color weren't eligible to vote. So I'm a little more skeptical of things approved by an electorate that didn't involve the entire citizenry.
Thank you both. A follow-up question. What is the Ohio Supreme Court's role in our constitutional system? Justice DeWine, you want to go first?
Sure. Our Constitution says that the Ohio Supreme Court has the judicial power. The judicial power has, had a meaning at the time that the Ohio Constitution was adopted, and it still has really the same meaning today. And that means our job is to, as Chief Justice John Marshall said, and Marbury v. Madison, is to say what the law is. We make definitive pronouncements about what the law means. That's exclusively the judicial role. Our role is to decide cases and controversies. We don't have a case and controversy language in our Constitution like the federal Constitution does, but I think that's been understood to be part of the judicial power, is to decide cases that raise concrete issues between litigants. And so I think that's really the judicial role, as opposed to the legislative role, which is to make the law, and the executive's role is to enforce the law. Interestingly, we had a case really that kind of dealt with exactly this issue a couple years ago. It's kind of relevant in the news right now. Some of you may have been following the United States Supreme Court's debates on Chevron deference and whether or not administrative agencies should have the power to issue authoritative interpretations of what the law means, at least when the law is ambiguous. We had that same issue in Ohio a couple years ago, and we decided that based on the separation of powers in the Ohio Constitution, that it was exclusively the judiciary's role to say what the law means. And so the judiciary does not defer to an administrative agency's interpretation of the law. Our job is to render that interpretation ourselves.
Mrs. Stewart, anything to add?
Not much necessarily. I agree that it's our job. I also think that it is our job to look historically at, particularly when looking at statutory law and legislation, to make sure that parties have the benefit of what the law really is, particularly if there is what I think is an oversight or ministerial mistake by the legislature. Example, we had a case last year, or a couple of years ago, Diller versus Dillard, dealing with a devise of a primary, the lapsing of a primary devise in a will. And the legislature had changed the law to add some things that were not to lapse under a will, and they said primary devise means, and they added those things. They left out or what should not, or devise means, and they added these things, and the word primary devise was not included. Now, under the common law, primary devise did lapse when the testator died. That was the common law. So our statutory law came in, our General Assembly came in and said, no, we don't want that. And we had 200-year history of not having a primary devise lapse when a testator to will died. And when this change of the law to add these couple other instances of not having it lapse, said devise means these three things, left out the word primary devise. And so someone went into court and said, hey, that primary devise lapsed. And the court said, doesn't make sense, but that's what the law says. And the Court of Appeals upheld it. It came to us. We ended up what we call IAing the case, dismissing the case as having been improvidently accepted, because the legislature saw that mistake and quickly went and changed the law. But I wrote a dissent and said, it's obvious that the legislature meant devise includes these things in addition to primary devise, because 200 years of history indicates that that's what they meant. But that's not what the law said, what this provision said. I will admit, absolutely said it means this, not includes this. But they quickly changed the law to say, so in that instance, to me, it was clear that the General Assembly meant to include primary devise as a devise that didn't lapse. And I wrote a dissent saying, you know, come on, but it didn't say that. But to me, common sense and historical analysis said that's what it meant.
So you both have talked about the legislature. Also, I want to bring in the conversation the executive branch. So what do you think are the constitutional roles of the legislative and executive branches, and then also the interactions between those branches in your branch?
Well, obviously, the General Assembly makes the laws. They promulgate the laws in our state. We interpret those laws. We have the final say in what's constitutional. We, of course, start by the plain meaning of the statute, and if it's plain and it means what it says, it means what it says. If it's open interpretation, then that's when we battle in our conference room and throw chairs, and no, we never throw chairs. But that's when we have an intellectual discussion back and forth about what it means, and sometimes in reference to other statutes. And the executive branch of the government enforces, you know, the laws that the General Assembly puts in place. So we can say what the law is, but we don't have the power to execute those laws. We don't have the power to enforce those laws. And so that's I think the primary differences in our branches of government.
Anything to add, Justice DeWine?
Not really much, other than, you know, when you think about the courts and you think about the role of the executive to execute the law, the legislative to make the law, the courts to interpret the law. Really, you know, what the courts do in large part is police the boundaries of separation of powers, right? They make sure that everyone stays within their lane. The legislature has wide discretion to pass all kinds of laws, whether we think they're stupid or whether we think they're great. But what they don't have the power to do is to pass a law that violates some right that's guaranteed to citizens through the U.S. Constitution or the federal Constitution, or to exceed the powers that they've been granted them. So really, within that separation of powers, the courts ultimately have to make sure that everyone else stays within their lanes.
We've talked a lot about the judiciary, the executive and legislative branches. What should the Ohio Constitution mean to Ohioans?
I think most Ohioans, and this is even including lawyers and law students, we don't think much about the Ohio Constitution. When you say the word Constitution, I venture to say the vast majority of people who even understand or know what it is think of the federal Constitution and the amendments to that Constitution. But I wish we as citizens thought more about the Ohio constitutions and the protections thereof, because oftentimes state constitutions give us more rights than the federal Constitution gives us. It gives us more protections. It is more reflective of what's going on in our society. And as we stated earlier, we have the right to petition to put a proposal on the ballot to amend the Constitution. But oftentimes, because I think law schools, and maybe this is a question we'll get into later, we primarily teach constitutional law because not all law students here at University of Toledo are necessarily going to stay in Ohio. You know, you might travel to another jurisdiction. And so, and you know, supremacy clause, our federal law is supreme, except when it's not, right? So thinking about our Constitution and as more of a cloak, and maybe a multicolored cloak that shields us more, I think might spur a little more interest in reading it and reading its provisions, and maybe getting some of the getting rid of some of the dead weight that's in there, and reconciling provisions that should be reconciled. But I wish we thought enough about it as a protector for us that people would spend more time learning more about it.
Mrs. DeWine?
Sure. I think as citizens, we're tuned to think of the United States Constitution as this document that guarantees us rights, and it's a really important part of our heritage, and that's absolutely right. But I think Ohioans also should think about the Ohio Constitution in a similar way. Historically, when this country was founded, the framers envisioned that the primary protector of your individual rights would not be the federal Constitution. The federal Constitution initially applied only against the federal government, but it would be the state's constitutions. And I think we've lost sight sometimes of the important role that state constitutions can play in guaranteeing individual freedoms that the people in the state have chosen to protect. If you look at the Ohio Constitution, if you start with the first article, Article 1, Section 1, it talks about Ohioans possessing certain inalienable rights. There's really no language like that in the federal Constitution. And language like that in the Declaration of Independence, but not in the federal Constitution. So the Ohio Constitution can be a source of rights protection that's independent of the federal Constitution, that gives people additional protections the federal Constitution does not. And I think we should all be a little more tuned to looking at that Constitution for what it is.
Just to add, Justice Wine talked about Article 1, Section 1, talking about the inalienable rights of Ohioans. It really is inalienable rights of men in Ohio. And of course, I know when you say the word men or men, you can think of adult males, or you can think of the human race, right? And so I can see that. However, would it change? Would it be so much of a burden to change that word from Ohioans or people? I mean, that's one of the things I think a throwback, because I think when it was written, it definitely meant men. And so that's a carryover from a time that keeps, I think, our Constitution from feeling inclusive.
Thank you, Justices. So we're in a law school where lawyers are being trained. If you could snap your fingers and give some advice to law students or legal educators about something that they might do different as students or as educators, in particular regarding the Ohio Constitution, but not limited to it, what advice would you offer? And we I guess we get what we pay for, so.
Well, I certainly think that we see a lot of cases where people might have had a really good claim under the Ohio Constitution, but they only talked about the federal Constitution. And the way our rules work, is the way just general rules of appellate practice work, is that you can't raise arguments for the first time in the Ohio Supreme Court. You need to raise those in the trial court and in the Court of Appeals. And that goes to the idea that people shouldn't be blindsided, that decisions are better made when there are levels of review. It's a pretty basic principle of Ohio of appellate procedure wherever you are, at least in this country. So one thing I would encourage people to do, particularly those of you, maybe if you're working in public defender's office, doing trial work, is make sure you raise those claims under the Ohio Constitution, so that when they get to the Court of Appeals and they get to the Supreme Court, we have a chance to consider them. Because there really are some provisions of the Ohio Constitution that on their face would seem to provide a lot more protection than the federal Constitution. For example, the United States Supreme Court has said that the Confrontation Clause doesn't always guarantee a right to face-to-face confrontation. if there's sufficient circumstances, you can dispense with the idea that you should be able to confront your accuser directly, face to face. Well, the Ohio Constitution, unlike the federal Constitution, uses the words face to face. So there's a pretty good argument that there are greater rights to face-to-face confrontation under the Ohio Constitution than the federal Constitution. But if you don't raise that argument in the trial court, if you just say, if you just rely upon the Confrontation Clause of the United States Constitution, you'll never have a chance to make that argument in front of our court, for example.
So we talked about law school, we talked about lawyers. Do you have any suggestions about we're in a university, how universities should educate differently to help young people know what it means to be an Ohioan, what it means to be an American? Changes to the educational program?
I think that, for me, starts with civics education. And I know that's hard to swallow when you're younger, particularly when you're younger than voting age, quite frankly. You don't understand and don't feel you need to understand our processes, our local governments, our state government, our federal government. And I think particularly the younger generation who no pressure but were really counting on to save the world, understood that you think in a way that we don't and can't think, probably because our brains are just too far past a certain time. And so I like to encourage young people to understand what your city council person does, what your state school board person does, or your local school board person, or your mayor, or your council, and understand those jobs and understand how they influence your day-to-day life. And then if you think you can add something, a perspective, a medical perspective in the state legislature, or an educational perspective, then run for one of those offices to make a difference and add some benefit, not just because you want your name on a plaque or because you want to be in the public retirement system. But it's to try to make your community better. I think any motivation to run for public office other than public service is actually fraud. I think those are jobs that try to make our society a better place, and we need as much diverse talent. And when I say diverse, I mean all sorts of diversity, intellectual diversity, perspective, backgrounds, and it's hard to be engaged in something you don't understand. So first start off by understanding what they are and realizing that whether you like it or not, they're going to have influences that affect your lives indirectly all the time, and in some instances directly. So I think civics education and putting it out there in a way that is palatable to the people who are engaged, be they high school kids or college kids or law students or the general community, our senior community, and just our community in general.
Thank you, Justice. Justice DeWine?
Well, I do worry, just generally at all levels in our educational system, that I don't see as much, or I worry that kids are not getting as much civic education as I would like to see. And I'd like to see robust levels of civic education throughout school. As far as law schools, I do think there's value in learning about your state constitution. I don't know if University Law School offers an Ohio Constitution class
This summer.
This summer. Well, I would encourage all of you to take that. I don't know if you all can, but I think that's something that certainly would be worthwhile.
And just to add too, a lot of people don't know that our lawmakers, the people who make our laws, are not all lawyers. They're the members of our General Assembly who get elected, and you don't need to be a lawyer to be a state senator or a state rep. I used to be of the belief that every member of our General Assembly should be lawyers, and sometimes I still feel that way. I think the quality overall would be better, but then I took a step back to say that even the lawyers need perspectives that are different from just law. They need perspective of educators and business people and healthcare professionals to help craft laws, and farmers in certain areas, because they make the laws that apply to everything. Your state rep in this area or your senator might propose some legislation that's meaningful to Lucas County, but it's going to apply to the whole state of Ohio. And those people need to work together to realize to not pass a law that helps one part of the state but hurts another citizens part of the state. And so I've retracted back from being all lawyers, but I think people with training in law will do better to craft laws that don't have unintended consequences and that work better for a longer term.
Thank you, Justices. One of the challenges in Ohio and the U.S. generally has been a challenge of people of different viewpoints engaging with each other in a civil manner. What are some of the things that you think lawyers, legal education, higher education could do, if you think that's a challenge, to respond to that challenge that Americans face?
I generally think the more you know, the less you scream and shout. I think that is one of the things I used to always tell my students is, the 5 Ps. Prior preparation prevents poor performance. And I don't mean just poor in quality, I mean poor in technique also. And so we're not always right. I mean, the 7 of us in the court, we try to get it right. But all of our decisions, probably the majority of our decisions, are not 7-0. And so we have intellectual discussions, and we write about what we think was wrong in a particular analysis. But, we are professional. We have a cordial court. And I have a great deal of respect for the intellect of all of my colleagues. I mean, they all went to law school, too. They all have various backgrounds, and I think the different perspective is good. And I hope that I listen to everything they say and have reconsidered positions too. I mean, I can even remember a case where I wrote a majority opinion, Justice DeWine dissented, and after reading his dissent, I thought he was right. And so I contacted the majority and said, I think Justice DeWine's dissent is right. I'm going to move to his position. Now, some in the majority stayed in that position, and I had drafted a majority opinion, so the ones who stayed in that position kept that opinion as a dissent. So there's a case out there where I'm in the majority, but I wrote the dissent. But that's what we have to do, because we're trying to get the case right. That's what comes first and foremost. and we try not, and we don't take it personally. And if you keep the job, the parties, the law, the perspective in the right place and don't take it personal. I think people who yell, scream, and shout take things personally, or they get emotional because they want you to understand what they're saying. So we have to be able to communicate in a way that says, I hear you, I understand what you're saying, I just disagree, and this is why. Please listen to what I'm saying.
Justice DeWine?
I mean, I worry, like a lot of people, that I think our society is more and more divided into kind of almost different tribes where people don't listen to each other, don't talk to each other, get their news from different places, more and more kind of ideologically segregate themselves, and I think that's really a big concern, and I think for you all as future lawyers, you really have an opportunity to play in helping to deal with that issue. I think lawyers more than anyone else are trained to listen to both sides of an issue, to understand both sides of an issue. You can't be a good lawyer if you don't understand what the other side is. And I think that's, having that training and skill is something that we need in society. I think you as lawyers, as you're going forward, really can have an important role to play in helping people understand that there are two sides of an issue, that the only way that we get to truth is you have to respect the other person's viewpoint. And if you're not willing to have that dialogue and debate, all you really have is shouting where no one can convince anyone of anything. And as lawyers, if we want to, if we want to persuade, which I think is what we're taught to do, then we have to be willing to understand where the other side's coming from. So I think that you should not neglect the important role you can play in society because of the training you're getting in law school.
And I might add one easy way that's not so easy to do that is check your egos and try to be aware of your own implicit biases. And we all have them.
Thank you, Justices. We've got time for your questions and comments. There are a couple of microphones, so if you want to raise your hand, and then you can ask your question. The Justices of Court are sitting on a court, so please do not ask questions about current or pending or likely litigation.
Yes. Hello, my name is Carol Lynn Morgan, and I came in from Boardman, Ohio. And reading the Ohio Constitution, Article 1, Section 16, states that all courts are open to the people. For every injury done to them, there shall be a remedy without denial, without delay. So how is it that the Supreme Court justices can then decide and pick and choose the cases they want to hear? They decline jurisdiction, although the appellate practice 8.1 states that the Supreme Court has deviated from the Constitution by doing so.
Great question. Justice DeWine?
Well, it sounds like you may have a specific case in mind, so I won't get into that. But what I will say is that the long-time understanding of the jurisdictional provisions of the Ohio Constitution is that, like the United States Supreme Court, the Ohio Supreme Court can choose which cases to exercise jurisdiction in. And every year we get about somewhere in the 600 to 800, sometimes 1,000 cases where people ask us to hear the case. And we pick about 5 to 10% of those to actually hear. So that's the way the process works in Ohio. That's been the long time reading of the Ohio Constitution.
And when it says the courts are open, I mean, even that isn't without some limitation. For instance, there are statute of limitations that you have to have when you want to bring a claim or a case in a trial court. If you don't get there within a certain period of time, you're barred. Same thing on appeal. If you lose at the trial court level or don't like the decision, you have the absolute right to appeal that to your intermediate appellate court. Traffic ticket, termination of parental rights, murder conviction, personal injury suit, you can appeal that. Court of Appeals doesn't have the discretion to say, nah, we're not going to take that. We have 12 appellate districts across the state, 69 judges who sit on those courts, and they sit in 3-judge panels. And they have to hear all the appeals that come through all 88 counties on that. There are 7 of us, and we hear everything in all 7. As a Supreme Court, we decide everything. All 7 of us have to weigh in on everything. Just this morning before we got here, because this is election time, there are a lot of things that are coming in where we expedited votes on election matters, and we've got a primary coming up soon. All 7 of us have to weigh in on it and make some decision and vote. We had to do those votes before we got over here. So if you can imagine 800 to 1,000 cases, and quite frankly, all of them don't have merit, but some cases that do have merit just want us to correct the decision of the appellate court, and we're not an error-correcting court. And I know that sounds strange to be the highest court in the state, but we aren't designed just to correct an error that was made at the Court of Appeals level. So can you imagine 7 people trying to hear 600 to 1,000 cases a year? It's absolutely untenable. It couldn't work. And so as one of the reasons the original Ohio Supreme Court traveled around and heard cases, it was untenable back in the 1800s, which is why there had to be a promulgation of laws to give us additional judges, appellate court judges and trial court judges, and it would just be untenable, and it would just be a second review of what our appellate court judges do quite well.
Thank you, Justices. Next question. There's somebody over here.
Hi, I'm Maria Martin. I'm an alum. I wanted to ask you about gerrymandering. Okay, you didn't freak. Okay, that's good. I'm curious about the last series of cases that went through, and that there didn't seem to be any sort of accountability or some sort of reprimand, if you will, of the numerous of cases that kept coming, and the legislator kept ignoring it. And I'm just wondering, oops, sorry, I really don't mean to be controversial. I really am curious as to the insight as to why they didn't seem to, and we're going to go back again for this issue, so I'm curious. Okay, thank you.
Justices?
So what was the question? Why?
Why there was no reprimand, or why there was no sort of like like that the legislator was not held responsible for bringing, numerous maps that were. I know you weren't on the court at that point, I don't believe.
Yeah, we both were.
You both were. Okay, sorry. So they kept coming back like with same maps, similar maps, and they just kept flouting what your decisions were.
Well, and at least the majority of the court. I think one answer to your question goes back to what we said earlier about the different branches of government. We can make the law, we can say what the law is, but we've got no power of the sword and no power of the purse. We could not, even though the majority said that the maps that were drawn were unconstitutional, go back and draw constitutional maps. The Redistricting Commission did do something, and even if we said no, that's not correct, when the majority said that, the constitutional provision did not allow us to then say, as some states have, our Constitution did not allow us to take it out of the hands and say, here, we're going to have somebody else draw them if you're not doing what we say. And so that's kind of the short answer to why the court, was not able to do any more than issue the decisions.
Justice DeWine, anything to add?
Well, I think you need to be careful what you say about this, because this is a matter that could be a more pending case. But the last redistricting case ended when the bipartisan redistricting commission passed maps that were that had bipartisan support. That we dismissed the case after that because, at least in the view of the majority, there was no new case. You couldn't just keep an old case open, and there's been no other case filed. So that's kind of where that is right now.
Thank you. Next question. Okay.
Hi. This is just a general question. What is your position on lower courts retaliating against people for contacting the disciplinary council? Is that a violation of constitutional rights?
I don't know if it's a violation of constitutional rights, but I think any jurist who retaliates because a complaint was filed should have another complaint filed against that person. I mean, the reality is, and a lot of lawyers say, I didn't want to file a complaint against Judge so-and-so or another attorney because I've got to go before that judge and I don't want that judge hurting my other clients. And particularly in smaller communities where, the lawyers and judges all kind of know each other. And that's unfortunate. And I think, personally, this is just my individual opinion, not the opinion of any of my colleagues, but I think the only way that is going to stop is if complaints are filed to say, I thought this judge committed a disciplinary violation, disciplinary counsel or the board found that there wasn't. That's fine, it's done, but now the judge is saying things or ruling in a way that is not normal in practice or has actually said something in retaliation. And so I think that's the only way that stops. And there have been lawyers who've asked judges to recuse themselves from cases dealing with that lawyer brings because of that very reason. Again, I think I think, and I think I can speak for all of my colleagues, and I said that we pride ourselves in upholding the standards that we think the citizens expect in the judiciary, and that's from the Supreme Court all the way down. And so, but we can't do anything unless it's brought to our attention.
Justice DeWine, anything to add? Other questions? Yes?
Hi, Justice. Thank you. My name is Stacey Alphonse, and my question is, in terms of legal precedent, how much weight does the Ohio Supreme Court typically give to decisions made by other state courts in their interpretation of similar constitutional provisions?
That's a good question. So, as far as stare decisis, as far as what we're bound to do, a decision of another state court interpreting another constitution is really not entitled to any stare decisis effect by itself. But I think that at least when I'm writing opinions, when I'm researching, I'm very interested in what other state courts are saying. I'm not so much interested just which way they've come out, but what I'm looking for is, is there persuasive logic? And often I'll see a case, say from Wisconsin, dealing with a similar provision of their constitution to ours, and I'll read it, and I think I will think, okay, that seems really well reasoned. I agree with that. And so, I think when we're looking at other state courts' interpretations of other constitutions, we don't follow them because they came out one way or the other. But if we find their logic persuasive, that's certainly something that can make a big difference.
And interesting about that is you're right. If it's something we haven't ruled on, or a case of first impression for us, then obviously any other jurisdiction that had the opportunity to weigh in on it, analyze it, is meaningful. For me, whether I agree with it or not, the analysis is still helpful. On the other hand, as an advocate, as a lawyer, one of the things I think is smart lawyering is when a lawyer has to say, that argument makes no sense, or it's not the law in Ohio, is evidenced by the fact that my opposition had to go outside and look. Or, this is not New Hampshire, this is not Iowa, this is not Wisconsin. But for me, it's all an analysis. It's if they have provided an analysis that we have not yet undertaken, it's helpful, regardless of outcome.
We have time for one more question. Is there a law student with a question? I see, Mr. Flanagan back there.
I guess this would go to both justices. You were in the majority on this specific case, State versus Daniel. It had to do with the arson registry. You talk about the separation of powers, and so reading that decision, it appears to me that you don't believe that sentencing is a judicial power separate from the executive branch. Could either one of you dive into that a little bit more?
I think we can, because that was an interesting case. That's a case where, just quick facts of it, if I recall correctly, and you can correct me if you remember it.
Yeah.
It's a case where we have a statute in Ohio that says if you've been convicted of arson, aggravated arson, you have to be on a registry for the rest of your life. And except for if the executive representative or fire marshal or someone and the prosecutor of the state recommends that your registration be less than for a period of your life, but it can't be less than 10 years. So a trial court, if the state and the executive recommend that you only register for 15 years or for the minimum of 10, then that the judge has the discretion to grant that. And so that was challenged, saying, wait, separation of states. It should be up to the judge to decide whether he or she can reduce that registration period, but the way the statute is written, the judge doesn't even have the discretion unless the executive and the prosecution and the executive representative petition the court. So even the defense can't ask. And that was a challenge, saying separation of powers. Justice DeWine, I think, wrote the majority opinion in that. And I was on the fence, I will say, about it, because there are statutes where the General Assembly says the legislature or the state and the executive get to trigger certain things. It did not impede the trial court's discretion once the trial court had discretion, but it did impede allowing the trial court to have discretion. And so I wrote a concurring opinion in that case saying it's not separation of powers, but it does walk a fine line because there are absolutely no guidelines in the registration, in that legislation for the registration period. So, you know, what constitutes who should get the grace of less than full time? I mean, there were no provisions that say, you know, if the fire started because someone was you know, careless and playing with, I don't know, matches, or if someone did it for insurance fraud, or if someone was killed by. There are no facts that indicate what should be a lifelong registration. And the meaning you would think for a lifelong registration is to protect the public. And then there were no guidelines for the judge to decide, should there be lifetime? Should it be 50 years? And, you know, if you're 70 years old and you're convicted of it, you know, 10 years in lifetime may not be great difference. But if you're 18 or 19, a lifetime registration is huge. And so there are absolutely no guidelines. What if the prosecution knows the family of the defendant? Then he cuts them a break. And what if you don't know them? So it's just rife with abuses, but it did not, in our opinion, constitutionally violate separation of powers.
Mr. Ryan, we have a couple minutes. You wanna add
Sure.
anything?
I don't want to get too much into the weeds on this case that probably only one person here has read, but the issue in the case was really whether sentencing a statute that limited what a judge could do as far as sentencing violated separation of powers. And what the majority of the court said was no. Sentencing is an area where judges have traditionally been able to exercise some control over sentencing, but there's also been a lot of legislative control. For example, if you're convicted of a F1 felony in Ohio, the judge gets to choose your sentence, but the judge can only choose it from a range of, I think it's 3 to 11 years now, which has been authorized by the General Assembly. For some crimes, gun specifications, for example, the General Assembly has said there's only one sentence you can impose, and you have to impose that one. So sentencing traditionally has been an area where the legislature has there's kind of a shared. It's not strictly judicial. It's not strictly legislative. Generally the legislature prescribes what the penalties are, limits what judges can do, and the judges exercise within that range. And this statute at issue here seems to be consistent with our traditional separation of powers understanding of that power.
Please join me in thanking the justices for their civil and thoughtful conversation.